Mr. Schwartz, there we go. There's Mr. Saval. Very good. And we are ready, Mr. Saval, when you are.
Thank you, Your Honor. May it please the court, my name is Sean Saval and I represent the appellant UCMS in this matter. At this time, I would like to reserve 5 minutes for rebuttal.
Very good.
And the lower court committed reversible error when it granted appellee's motion to dismiss the complaint after an amended complaint had already been filed 1 day prior. That was in contravention of established Supreme Court precedent in Bocaberger v. Forum, which was decided in 2005, which clarified any lack of clarity of Rule 1.190A, which grants leave to amend as a matter of right, meaning that the trial court simply has no discretion to deny amendment of a complaint one time.
Mr. Saval, is this sort of lawsuit a proper vehicle to deal with an appraisal? And if I may analogize, the appraisal process is something like arbitration, and it's supposed to end the story. And if I were in a typical arbitration, you don't file a new lawsuit to challenge the award. If you win at appraisal, you either move to confirm the award, or if you don't like the decision, you move to vacate. And neither of those things sort of happen here with your first and with your amended complaint.
Well, Your Honor, you bring up a good point that it's treated like arbitration, and the arbitration code actually 682.13 and 14 say that there are certain conditions that you can bring before the court, challenges to an arbitration, which has been extended to appraisals. If the initial complaint did not do that appropriately, the lower court should have given the opportunity at least one time to amend before exercising its discretion to dismiss the complaint.
What about the time requirement of appealing or contesting the award? Why was that not met?
There are 90 days under the arbitration code to challenge an arbitration award.
But under the agreement that the parties entered, wasn't there a much shorter time frame?
I don't have that available.
Okay, you can continue. And if the original complaint was not timely, we'll assume that you don't have it in front of you, but if it was not at 2 months, then would the amended one, if that's when you were eventually coming up with the arguments, that would have been 6 months or so, correct?
That's correct. However, I would point to back to Rule 1.190, as this is a civil action governed by the rules of civil procedure ultimately, which has relation back to the date that the initial action was brought on March 4th, which is less than 60 days after the appraisal award. And I believe that the rules of civil procedure ultimately control a civil action, even of this nature.
It strikes me that the thrust of both the initial and the amended complaint is to get a do-over of the appraisal process. And we know, if you look at I guess it's the NOAA case out of the 3rd DCA, they very strenuously say you don't get a second bite in the appraisal process. Certainly, it strikes me not under the facts that we see in your particular case.
That I believe that going to the merits of what is stated in basically that I want to draw a line between the procedure and the substance of the arguments in the motion to dismiss, and I still rely on Bocaberger to say that ultimately it's not appropriate to dismiss a complaint which is rendered moot by an amended complaint. If the amended complaint failed to meet the burden of pleading under the facts alleged, and the trial court determines that no set of facts can ultimately allege a cause of action, then the amended complaint can be dismissed. But still, under the rule of civil procedure 1.190A, that cannot happen until there is a motion to dismiss the amended complaint.
But the practical result is, and I will admit, I was troubled with the trial court's analysis of the right to amend. But if, as Judge Stargell noted, the lawsuit is late, there ain't nothing's going to solve that problem with an amended complaint. It's still late.
I think, as Your Honor referenced the lower court's ruling and what was announced on the record at the motion to dismiss hearing, which was a complete misconception of the amendment as of right standard under 1.190. So that was the basis of the ruling. I know that the motion was called a motion to confirm the appraisal and dismiss, but what the court did was simply to dismiss, and by dismissing, that did not confirm the appraisal award. That simply dismissed the case and discharged.
Well, again, as a practical matter, maybe you technically don't need an order confirming, because there's no exchange of money that's happening in this case, given the deductibles that your client had, or the S and or had.
Understood. Well, Your Honor, I would say that ultimately the procedural impropriety of how the lower court acted ultimately is the appellant's position of what takes the day, and that Boca Berger is controlling. The lower court disregarded Boca Berger when rendering its order, and that requires reversal. This court has repeatedly upheld Boca Berger in Williams v. Gaffin Industries in 2012, Fowler v. Paradise Lakes, and DOT v. Telesor both in 2014, and again in Alberton versus Barness in 2018. All of those cases reaffirm the.
Let me go back. Judge Stargell asked you a question and you didn't have the answer. He didn't pursue it, but this issue was raised in the brief. And so I'm concerned that you are unable to tell us what time frame applied under the contract to challenge the appraisal award. And we know that the appraisal award was signed by the appraiser and the second by the umpire and one of the appraisers within 60 days of the lawsuit being filed. So do you not know whether or not the contract requires filing of the suit within 60 days, or can it be some longer period? And that seems to me, based on the questions you're hearing, if you can't get around the timeliness of the challenge, it seems to me you cannot prevail in this case, despite the error of the trial court in not allowing the amended complaint, because the end result is absolutely the same. You can't show harm. So let's see if we can nail that issue down.
Yes, Your Honor, and sorry to say, I don't have the time frame under the contract. I'm not sure that was.
I suspect Mr. Schwartz will answer that question for us.
Thank you, Your Honor.
If you want to continue or turn it over to Mr. Schwartz, whatever you prefer.
I think I've made the argument, so I'll turn it over to Mr. Schwartz and reserve that 5 minutes for rebuttal. Thank you, Your Honor.
Very good. Thank you. Mr. Schwartz.
May it please the court, Steve Schwartz for Cypress, the property homeowner insurer in this case. As this court has already observed, property insurance claim appraisals are intended to end the dispute as to the amount owed for a claim, not to spawn another 18 months of litigation. More than 20 years ago, the Supreme Court directed, the Florida Supreme Court and Johnson Nationwide, that where the only issue is the amount of loss and controversy and where the insurance company has confirmed coverage for the claim, it's for the appraisal panel to decide the amount that's owed, not for the courts. Thus, the scope and price of a disputed claim as to any loss-related repairs is for the appraisal panel, the umpire, to make a definitive ruling. In this case, the appellant roofing contractor presented a demand for a full new roof on this house long before the appraisal was ever requested by Cypress. The basis of their claim was, gee, there's more than 25% of the roof that's damaged, so by the building code, we need a new roof.
So, Mr. Schwartz, are we get an answer to the question of what the time frame is for filing a challenge to the appraisal award?
So the timing is not per se directed by the policy itself. The insurance policy sets forth the sequence of events to create the appraisal panel and to render a payment based upon the award. I think it's more in keeping with statute 44103 and rules 1.820 and 1.830 as to whether the timing is 20 days to contest an appraisal award, like an arbitration award, or at worst 30 days if you're going to use the arbitration analogy. I think the statute and the rules govern the timing of the challenge. In this case, there was no challenge on any meritorious basis to the amount of the appraisal award for more than 2 months. And then if they want to travel under their amended complaint, more than 6 months. I think the timing by statute and rule at worst is a 30-day deadline, just like contesting a final judgment amount for some sort of error. Now, all of the district courts agree with the Supreme Court that the only meritorious challenges to an appraisal award, somewhat akin to an arbitration, would be collusion, fraud, or a math error. None of those three were raised in this instance. Worse yet, in this case—
Let me ask a question then that goes to the merits of this. Assuming for the sake of this argument that the appellant presented evidence that more than 50% of the roof had to be redone, and the appraisal award essentially agrees with that in a way because it says you're going to put this, I think it was hydrosheen all across the roof, which is 100% repair. Assuming that the appellant is knowledgeable of what the ordinances require, would they not have been entitled to challenge the appraisal amount, saying, you've got it wrong, you didn't apply the correct ordinance information, you have found more than 50% of repair, that requires a whole redo under the current ordinance? Are you telling me they have no ability to raise that issue?
under that set of hypothetical facts, I think they may have the right to raise that kind of an issue, but that would presume that the appraisal panel, the umpire and one of the two appraisers, two against one, had actually made some sort of a finding that more than 50% of the roof needed some sort of a repair. In this instance, what we know is the roofer presented a 100% full replacement of the roof, so a substantially broader scope of repair than first Cypress had agreed to pay, and second, the appraisal umpire rejected. The umpire rejected that broader scope of repair. Had the umpire rendered in some sort of a finding that we could easily discern that, oh, I think more than 50% of the roof has to be repaired, but I still find that you don't have an entitlement under a building code to so-and-so, that might be an appropriate challenge. I've never seen it before. I've never seen an appraisal panel go to that level of explanation.
Well, I guess my question goes to if, as I understand the appraisal award, the product that needed to be applied to the roof would have been for 100% of the roof. Is that correct, or do we know?
I'm not sure we know, but under a HydroSheen coating of a roof tile in order to match color, the entire roof might be colored, but that doesn't mean the entire roof needed repair. There were a very small number of tiles that actually needed to be fixed.
So it seems to me that you may be entirely correct in that analysis, but if the appellant felt, wait a second, that is not consistent with what the ordinance says, we will never be able to get this repaired using HydroSheen because the county or the city treats that as a full repair to the roof. It sounds like you agree, if this were a timely challenge, that would be something that the court could determine. Whether
Possibly so, Your Honor.
Okay.
And Mr. Schwartz, help me understand, the award, as I recall, had some language that the umpire and appraiser did not consider the ordinance and regulation provision.
So in the award, there were 4 separate subcategories of coverage that were quote unquote not appraised. They didn't just point out ordinance and law. They didn't consider contents. They didn't consider other structures. They didn't consider loss of use, additional living expense. And the reasoning is necessarily because the sole scope of repair that the umpire and one of the 2 appraisers deemed appropriate as loss related was a small portion of the roof that needed some sort of repair. I think the decision in NOAA, the decision even later by the Middle District of Florida in Venture Construction is the better reasoned approach, because we can't allow some do-over second appraisal or some attempt to reopen the entire inquiry after an award's already been rendered, particularly where in this case, the same full roof replacement under a building code analysis was exactly what UCMS presented to the appraisal panel. The umpire rejected it. The umpire rejected that the building code under ordinance and law would require a greater scope of repair. I think that's the only way to read the award. But if we allow post-appraisal, particularly 6 or 8 months later, some sort of an attempt to create a new scope of repair, we have now turned on its head the principle of finality of awards, appraisal awards, where the appraisers decide the scope of repair, not a lawsuit, not a court that becomes some separate additional appraiser months after the fact. I think the NOAA decision is better reasoned in that regard by the 4th District. I think the Venture Construction case in the Middle District is likewise following the better approach here. I think that's the approach the 2nd District should certainly follow. Again,
Mr. Schwartz, in the
Yes.
judge's order, I mean, it's a very bare bones order, and she says you're challenging the appraisal award, therefore you lose. I mean, that's the bottom line of what she says in the order. At the hearing, she raised a couple of questions, but she did not make a finding that the initial complaint was untimely, did she?
she did not.
So
I think her basic analysis.
how do we know what the judge, when the judge determined that you can't go forward, what can we hang our hat on in terms of understanding a legally cognizable basis to say, too little, too late, you can't challenge this?
I think the best understanding, perhaps the only, of what Judge Creer was driving at in her repeat questions of counsel at this hearing, both as to the original complaint and the amended complaint. What is it that you are challenging? Are you challenging the appraiser's decision as to the scope and price of the work? And because counsel could never get around that issue, the court determined, I think in a somewhat abbreviated manner, that there was really a futility of a challenge because there was no meritorious contention as to what was wrong with the award in the first place.
Let's, again, assuming for the sake of argument that the challenge indeed is what the trial court noted, that it's a challenge to the appraisal work as to the scope of work to be done. And again, because we don't get to review what happened in front of the appraisers, that's for the trial court. So assuming that the appellant can establish that we introduced into evidence the ordinance, we introduced into evidence what would be required in order to finish this repair and be permitted to finish this repair. And the appraiser not only didn't make a finding regarding that issue, but the umpire affirmatively said in the award that it was not considering the ordinance. Wouldn't that be something that the trial court would in fact be entitled to resolve if the complaint were timely filed?
I think it comes back to how much of your hypothetical set of facts were actually shown by the record to the trial court. In this instance, there was a self-serving, self-prophecy building permit application after the award had already been rendered, asking to replace the whole roof.
We don't even need to get to that issue. I mean, the argument is that or as I understand it, part of the argument is that the appraiser and the umpire failed to take into account the extent of repair needed to the roof, which is inconsistent with the requirements of the ordinance. Is that something that an appellant in any case would be entitled to say to the court, look, the appraiser affirmatively said, I'm not taking into account ordinance issues, and we think we established that the ordinance is going to be a problem, help. I mean, is that not something that they can get relief from the trial court on?
I think the difficulty here is the assumption that ordinance and law would have changed this result. In this instance, the appraisal panel decided the scope of repair didn't trigger the 25% building code rule. I think that's the appropriate way to interpret their comment in the award.
And
we
if
didn't appraise ordinance and law.
Correct. If they were incorrect in that analysis, and if the appellant preserved that issue in front of the appraiser and the umpire by presenting evidence or establishing the question, I mean, it seems to me that is an issue that the trial court can in fact consider in determining whether the appraisal award was appropriately made based on the information in front of the appraiser and the umpire.
I think if we go down that road, then as a tangential argument, the argument would be that is a quasi math error type mistake. That is one of the three prongs of challenging an award.
But here's the bottom line of what I'm concerned about. The judge made no findings. So we don't know if the court said this isn't a math error. The court didn't say, well, you didn't put in anything in front of the umpire and the appraisers dealing with the ordinance. You didn't contend that this was more than 25% of roof repair. Therefore, you lose. That might be findings that would be sustainable, but can we get there on this record and on the findings the judge made?
I think you can. And I rarely in an oral argument bring up a tipsy coachman argument, but I think the judge was right even for the wrong reasons. At the end of the day, it is not for the court to go back behind the appraisal decision and decide what did they consider or not consider. They look at the scope and price of the award, and that should be deemed binding. I would agree with the court if Judge Creer had been a little bit more explanatory. It would be an even easier decision for this court to simply affirm. I still ask that the trial court be affirmed in rejecting the attempt to attack collaterally an appraisal award months after it's been rendered, and in effect, make the same argument they presented to the appraisal panel. More than 25% of the roof ought to be repaired. That's why we need a building permit for a whole new roof. All of that was presented to the appraisal panel. The umpire rejected it. I ask that the court affirm the lower court and leave the decision in place.
Very good. Thank you very much, Mr. Schwartz. Mr. Sable.
Thank you, Your Honor.
Thank you, Your Honor. And Judge Silverman, I think you highlighted a few things. the incomplete record, because this was on a motion to dismiss, looking at only the four corners of the complaint, there were many items that were referred to by Mr. Schwartz that are simply not supported by the record, such as what the appraisal panel and the umpire actually looked at and decided. All we have is a piece of paper saying the award, and I think completing the record would really expand the trial court's understanding of what happened, and if indeed this does come in.
Let me ask you a question then. I don't recall this from the record, and maybe you do. Did you argue the theory that I am positing to the trial court at that hearing?
Your Honor, I argued that the arguments that there is 100% repair that was done is made in the amended complaint, which the court simply struck without considering it.
But in
So
terms of preserving an argument for this appeal, did you argue to the trial court, one, the timeliness of the complaint, the initial complaint, two, what the problem with the award was in relation to why it could not be sustained and the trial court had the authority to send it back to the appraisers and the umpire?
I don't recall offhand. My argument below was concentrated on the procedural nature of a motion to dismiss that came after after an amended complaint had been already filed, which did raise arguments that were simply not, pardon me, it raised a theory that was not raised in the initial complaint, and I believe that the procedural nature of a litigant's entitlement to amend their complaint to raise new legal theories, which is what happened in Bokenberger, which is what happened in Albritton, and that was the approach that was taken as the attorney in the lower court. As far as the arguments that were made towards the propriety of the timeliness, I don't recall the timeliness being, well, there was the too little, too late argument that was made by the appellee below. However, that, as Mr. Schwartz said, that was no fine point on where that timing actually came from. I believe he was relying on Florida Statute 44.103, which is the statute memorializing the arbitration rule as far as court-ordered arbitration. However, I believe that the more pertinent statute is from the arbitration code, which is 682.13 and 14, which has a 90-day time limit for challenging an appraisal, an arbitration, which has been extended to appraisals by Florida courts. So I believe that the timeliness wasn't an issue, but it certainly, as a matter of law, is legally timely, having been raised within less than 90 days. And I believe that appellee has essentially conceded that there may be circumstances where an appraisal can be challenged, narrow circumstances, and I believe that there have been allegations made in the amended complaint that did not have a chance to be fully fleshed out, and that is ultimately procedurally what I think what the appellant is seeking, and what 1.190 entitled the appellant to. So I would ask that the dismissal be reversed by this court for either reinstatement of the amended complaint or further proceedings with leave to amend, should the appellant so choose, to allege a viable cause of action. And I thank your honors for the time today.
Very good. Thank you both very much. You can go ahead and exit the courtroom by hitting the leave button. The